All right, today is March 1st, 2024. It's just a couple minutes after 9 a.m. I'm Judge Toto. This is Court 201. This is the matter of Trigg versus Middlesex County Prosecutor's Office, docket L 40924. We are on the record. Counsel may have your appearances starting with plaintiff's counsel.
Of course, Your Honor. Nicholas Mileski from Metz, Shiro, McGovern, Mineta, and Mileski on behalf of plaintiff Raymond Trigg.
Thank you.
Good morning, Your Honor. Mike Williams with the Office of County Counsel here on behalf of defendant Middlesex County Prosecutor's Office.
Thank you.
Good morning, C.J. Griffin of Pashman-Stein, Walter and Hayden for New Brunswick today.
Very good. Thank you all. All right, so I've read everything submitted. I'm willing to hear your additional arguments that you have, and I may inject a bit because I want to see if I could focus some of the arguments today. But Mr. Mileski, we'll start with you. Anything you'd like to add to your papers?
Yes, Your Honor. I'm really going to kind of highlight what was filed. Just as preliminary threshold matters, first of all, there is no action by the prosecutor's office that's a necessary predicate here for Lieutenant Trigg's action to stop access to his personnel file. The prosecutor's office had advised Trigg that they received the notice for disclosure. Lieutenant Trigg then asked the prosecutor to wait on disclosure, and Lieutenant Trigg filed this action. And then the prosecutor's office is delaying dissemination, waiting for guidance from this court. So under the Uniform Declaratory Judgment Act, there is no other action that needs to take place. This is it. This is the action that's going to occur. And to say that there's no action is silly. Second, New Brunswick today does not appear to have a sufficient interest in accessing plaintiff's personnel file to warrant release. The Lloydman Court, and that's Lloydman v. Kimmelman, 102 MJ 98, page 108, 1986. The Lloydman Court held that more than a showing of good faith and citizen status are required, and it's not sufficient to simply say that there existed corruption in order to circumvent the public's interest and confidence. That's basically what New Brunswick today is doing here. They may well have a good faith argument that they want to write an article on the contents here, but citizen status is not enough. And to say that there was corruption is just, that's kind of neither here nor there. There has to be some further link, some further evidence to pierce the interest and confidence, and New Brunswick today has not done that.
Well, here's my issue with that. And my initial thoughts in reading the papers was that they should come in to intervene. I have some concerns with the request that they made in terms of it not being specific. Is it the IA file? Is it the personnel file? Who has the file? Is it the police? Is it the prosecutor's office? And maybe that's something they need to cure. But I do believe that they have an interest, and their voice would need to be heard with respect to whether or not those documents should be turned over at some point.
I fall back on our argument that I made at the first order to show cause hearing. Under both the Lloydman and the Rivera elements, the court's decision will or should be the same as to whether or not the documents will be released. New Brunswick today's input really is neither here nor there. It doesn't provide anything to the court that the court that may change the court's opinion as to whether the documents are available under the common law right to access.
Okay. Thank you. Mr. Williams?
Good morning, Your Honor. Middlesex County Prosecutors doesn't have much more to add than our papers.
Okay.
You know, we don't take a position as to whether the Rivera or Lloydman factors go one way or another. We just think that the appropriate disposition is to provide the documents for camera review so that the court can review them and make an assessment as to relevant factors based on those documents.
Okay, very good. Attorney Gray?
Good morning, Your Honor, or perhaps I should call you the records custodian for Middlesex County Prosecutor's Office, because that's what Middlesex County Prosecutor's Office is asking you to be. So I want to just start at the top of my brief. I'm not going to repeat my brief, but the issue that was first raised by plaintiff's counsel, whether this action is right for review, and we maintain it's not. The mere filing of an opener request or a common law request does not create a controversy, and I cite the FOIA case law because I think it's helpful, where under federal FOIA, in order for a third party to file an action to have a live dispute, there has to be a decision by the government. And the reason why that decision by the government is important, because otherwise the court would just be adjudicating all sorts of cases, because the government receives hundreds, and in federal government receives thousands and thousands of requests. And so if the mere filing of a request creates a cause of action, courts will be inundated. So what should have happened here, and what the Supreme Court in recently in Gannett versus Township of Neptune said, when they discussed these arguments, they were addressing arguments about, it was about the right to attorney's fees, but they are addressing the arguments by public agencies that, you know, it's really difficult for them to perform common law balancing tests, and so therefore they shouldn't be penalized if they get it wrong by being subjected to attorney's fees. And the Supreme Court was sympathetic to that and said it is more difficult than Oprah. I disagree, but that's what they held, and so there won't be attorney's fees. But what they said is that doesn't remove the burden of the agency to do the common law analysis. And towards the very end of the opinion, they offered suggestions to public agencies to handle this, and they say, we recommend that you receive training with respect to the common law right of access, and that they, the custodians, be directed to carefully review each request and provide a response that comports with the law. And then they say, on the other hand, to the extent they can, requesters should also articulate interests to help the custodian have information, because that would, because otherwise it may end up in an unnecessary dispute and wasting both parties' resources. And that's what's happening here. The Middlesex County Prosecutor's Office is asking you to be the custodian to decide. They solicited they let Mr. Trigg know. They should have heard his side of the story, heard Charlie included in his request a lot of reasons why it should be disclosed, and then they should have done the balancing. And if they agreed to release it, then Mr. Trigg could have challenged that decision. And if they denied it, then New Brunswick today would have the authority to challenge it.
Skipping ahead though, right, we're at the point now where the prosecutor's office isn't taking really a position on it, which, and asking for the court to review it. What of the request that was made and what I deem really some lack of the request being specific, now knowing that what was asked, the personnel file, was with the police department, not with the prosecutors.
We've clarified, I think, in our brief and since that it's the IA report.
No, I know that, but that's not what was asked for, right? And you're saying there should be a determination by the entity as whether or not they're going to turn it over, right?
Right, and even if so, yes. So the response should have been, if that was the objection, we don't have the personnel file. We have the IA file, and we're denying it, or we're granting access to it. Yeah. There's always that opportunity, but the prosecutor's office is taking this position. Essentially, it seems that anytime there's a request for an IA file, or as we'll hear later today, maybe something that's kind of controversial, they're not going to take a position, and that just can't be. And in terms of the intervention and the importance of New Brunswick today in this proceeding, it's just like the next case. Of course, the plaintiffs don't want the requester here, because I submitted a lengthy brief and briefed all the issues and tried to help Your Honor
Yeah, no,
determine the
we
balance.
persuaded me with that. I think it is a necessary party, or at least, I don't want to say necessary, but it's a party that has a right to be here.
Right.
You know, the question is, procedurally, right, I want to keep this on track. What's the proper procedure right now with respect to the request, with respect to the plaintiff's argument? Because I think, no matter what happens, I think we're back here making the same arguments all over again.
Yeah,
Right?
and I do understand for purposes of judicial economy, it might make sense to weigh in on the merits. I guess at the same time, and I just, we talked about this strategy, at the same time, it's important to me that the prosecutor's office doesn't continue doing this, because what really happens is that then a requester gets dragged into a proceeding that they don't really want to be in, and probably don't have the funds to be in, and they feel this obligation to come participate, because if they don't, then there's going to be an order that some document is secret, and it prohibits everybody else in the future from getting it. And so that's why these sort of reverse proceedings are difficult. And at least in federal FOIA, when it happens, you have the agency that said, no, we made a determination, we noticed you, and then when the third party goes to court, then the agency defends that decision on behalf of the public's right of access. That's not happening here. So yes, my client wants the internal affairs report. So if Your Honor wants to reach the merits, okay, but our concern is we just want procedurally this not to happen again, and that the prosecutor's office knows that they have to take a position and then deny it or grant access to it, but don't just let the court be the records custodian.
I feel like we're going to be having this discussion in a bit.
A little deja vu. Although, yes, a little, I'll talk about that then. And then in terms of just the citing Lloydman, as he noted, it's 1986. This is not 1986, it's 2024. And Rivera was a landmark decision that completely changed the landscape as to internal affairs and how you conduct balancing tests. Just within the past 2 weeks, there was an unpublished opinion by the appellate division in 21st Century Media versus Township of Ewing, and they flatly rejected this notion that a mere citizen's interest isn't enough in the context of internal affairs. It is. The public interest is what's at stake, and when you look at the Lloydman factors, I agree that I don't see how any of them weigh in favor of confidentiality, and the Rivera factors all or mostly weigh in favor of access here. And so we think that if Your Honor reaches the merits, then we are entitled to the report, and at the very least, we're entitled to a in-camera review. And I know that there's some discussion that this is like it was minor discipline, but that's part of what we need to see, because the allegations weren't something minor. The allegations were something serious. If there was a holding that it was some sort of misuse of technology, that could mean a lot of different things. We're lawyers, we know how to make something serious sound not serious. But it could also mean a variety of reasons why it might have come to that conclusion. But what we do know based on the reporting is that there's a restraining order. The recent reporting suggests that restraining order was not lifted in another proceeding. So we think that this is something serious that the public has a right to know more about.
Okay, thank you. Attorney Mileski, anything you want to say in rebuttal?
No, Your Honor, no.
Attorney Williams, anything?
I just wanted to point out some of the just procedure,
Sure.
as I misunderstood. Counsel has suggested that the role of the prosecutor should be first to get the request and then hear from all sides and then make its own balancing test. Even in this case, what happened is we did make Lieutenant Trigg aware of the request, and he chose to go to court as is his right. And so I don't know that there's anything improper with the way we did it. He has every right to seek judicial relief if he's aware that a request was made. And but for that, the prosecutor's office would have made that determination. But by no means can that preclude the type of relief that Lieutenant Trigg sought.
Any last words?
If I could just clarify, I'm not saying that the custodian has to solicit information from both sides. They can. Sometimes it's helpful. In most cases, when someone requests, including this case, I don't think that New Brunswick today needed to provide all the information they did, but they certainly helped the custodian along by seeing the arguments in favor of disclosure. So I'm not saying they have to, sometimes they do. So I don't think it's improper for them to say, can you tell me what your reasons for wanting it are? Can you tell me why I wouldn't give it? But they have to make the decision because they're the custodian, and until they do, there's no cause of action because there's no dispute. Because the public agency could have said, we're denying access, and so Mr. Trigg at that point would not have a cause of action. New Brunswick today would. And so if the response to every request for internal affairs records is file an action if you want to do something about it, we're not taking a position, then I think that you're gonna have a lot of cases, especially in the next couple of months, because the internal affairs major discipline reports are coming out and that sort of thing, so.
Knowing where the court's headed with this, what are you asking the court to do today? I know what your papers say. I mean, what would you like to see the court do?
Well, we want a decision that makes it clear that Middlesex as the custodian has to make the decision and that there's not a controversy until that happens. So in Carter, the court said that I say Carter, but it's technically in re matter of Firemen's Association, but for some reason the Supreme Court subsequently called it Carter. The Supreme Court said, no, they couldn't have sued because only the OPA requester had the right of action. But in the interest of judicial economy, we're gonna decide the issue. So we would be fine with that approach, but we just want a ruling that this procedure shouldn't happen again, so the prosecutor's office knows they have an obligation to do that.
Okay. Anyone else? Very good. Thank you very much for your arguments. I will get you out an opinion. The interim order stays in effect until I get the next order out. So thank you all. I'll probably have that for you early next week.
Thank you.
All right, thank you very much, Your Honor.
Thank you. For the record,